Now, what does the officer do? It's a median of one of Tucson's busiest streets. There's traffic going by both ways. He's got to think about her. He's got to think about the safety of the officers.
Hey, Jared.
About the safety of the public. One of the reasonable things that he can do is, and probably we argue the best thing he can do, is
Forgot my
take
glasses. I'll be right
physical
back.
control of her and get her off that median.
Of course. But,
Be right back.
but according to her evidence, one of the things he does is shove her face into the bark of the palm tree. That's not getting her under control and getting her off the median. That's something distinct. So her evidence is he deliberately pushed me into the palm tree and caused me injury. So that's what you've got to contend with.
Right. We have held that an officer is not entitled to qualified immunity on the grounds that the law is not clearly established every time a novel method is used to inflict injury.
Okay, thank you very much. I do have one further question, and this is for the courtroom. You're a law student?
That's correct, Your Honor.
And where are you a law student?
I'm a third-year student at William & Mary Law School.
Okay, thank you very much. And we would like to compliment you on the quality of your presentation. I'll compliment you too, but you do this for a living.
Yeah.
So,
In the early morning hours of June 22nd, 2016, Jacob Tellez and Vasilia Mena were walking home from an evening of having drinks and got into a domestic dispute. They eventually ended up in a traffic median in the middle of once considered America's ugliest street, Speedway Boulevard in Tucson, Arizona. They were arguing while standing by a palm tree close to the Speedway and Swan intersection. Tucson police officers Robert Massey and Sergeant Laura Petty were parked at a Chase Bank that sits across the street. They wasted no time as they seen an opportunity to confront the couple. They wanted to make sure there was no violence in the area unless they were involved. Officer Robert Massey wrote in his report that a possible domestic violence occurred and that Mena had bloodshot eyes. He also believed she may have been underage while intoxicated. And in his eyes, that's all the reason to investigate further. So he demanded her to step away from her boyfriend, and he also
Playborn dirty.
ID. And here's something we don't often
Did you get my reply? Yeah, I caught a strike for John's Plantation. So, yeah. I'm gonna wait for a response from the copyright holder, and
now his attorney is arguing for qualified immunity.
but once it's resolved, I'll probably get a week off. We'll see.
The district court held that Massey had reasonable suspicion to handcuff Mena, even though no domestic violence had occurred between Mena and her boyfriend. And she was also not underage. The truth is, the district court held
Sorry,
that Massey had
it was connected to the
reasonable
building.
suspicion to handcuff Mena.
We're back.
And denied qualified immunity on the excessive force claim. The court identified the factual disputes as questions. 1. Did Mena resist arrest? 2. Did she jerk away?
No, it was definitely worth it, man. I was.
3. Was she
It's
inebriated?
even if I end up having to take it down and I get the week off, it's still available on Rumble and all the other networks I was on. So I didn't kill any of them. I just decided to say. I just said fuck it. It's kind of a test, really. I don't think I'm going to get the week off though. I think even if they say no and I just take the strike, it should be all right. Because the copyright strike doesn't mean an automatic week off. So we'll see.
Watch as Massey's attorney argues his version of events, and watch the judges deny Massey's appeal, and also watch Mena's young attorney impress these judges with his presentation. We'll see you at the end of the video and give you our final thoughts. Let's get right to it, folks.
Hey, please the court. Good morning, Your Honors. Dennis McLaughlin for the city attorney, representing Officer Massey, Tucson city attorney. I would like to recognize the skillful briefing of my colleagues, Viola Romero on the open
Yeah, we'll
brief
see.
and,
I've gotten plenty of them. This is my first time getting a strike since I've been monetized,
with
so we'll
Your
see
Honor's
how it goes.
discretion And consistent with our colloquy, I would like to reserve, excuse me.
I mean, we'll see.
I will do that. Qualified immunity case,
It let me post a short earlier. I didn't even know about it until I
two-pronged standard.
was just
that
checking
is
on the status of that little short.
violation, and it needs to be clearly established in law at the time.
I don't think I got a
events occur.
suspension. I think I just got the strike.
Neither of those have been met here. This case is 2.5 years old, and the plaintiffs have never.
I'd like to have it
case
removed.
that actually makes clear that there was that this would have been a violation for what the
I
officer
emailed
did.
Can you
the
tell
copyright
me what
holder, though.
level
We'll
of
see.
specificity is required to meet that prompt? Does it have to be a case that says
hypothetically slamming a woman's face into a palm tree is a violation of the Constitution. But if the next case is slamming the face into a pine tree, do you have to have a pine tree case? What is the level of specificity?
Your Honor, what I understand the level of specificity to be is you don't have to have clear, all that the Supreme Court has said is you don't have to have clear precedent that's exactly on point, but it has to be reasonably clear, I would say more than reasonably clear, to a reasonable officer that what he or she is doing is wrong. And we do not have that in this case. I understand your concern. We do not have that in this case. We have a situation where a woman is in the median, she's intoxicated, she's antagonistic, she's uncooperative, she won't move away from the person she's with, which means that, and she won't give identification. So the officers can't investigate anything of what they are suspecting. Moreover,
So let's slam her face into a palm tree.
either possibly domestic violence, Your Honor, or underage drinking. And
How old was she? I didn't even.
if you look at the pictures, which I think are ER 39,
The one with the big gashes on her head.
yes, she's 22. I believe she's 22 at the time. But she's one of those lucky people that it's hard to tell how old she is, whether she's younger or older.
It sounds as though in this instance, under your argument, she's not lucky at all, because you're using that against her.
That's true, Your Honor, but that's right. But the point is, the officers don't know when they're investigating whether she's underage, and that's one of the things they're looking for. I do want to emphasize, Your
I
Honor.
don't think there's any serious dispute that they had some ground for the arrest. I mean, just the refusal. I mean, I don't think that's part of the fight.
Right, or detention. The court actually found that there was reasonable grounds for the detention, and there's been no appeal.
Right.
So now, what does the officer do? It's a median of one of Tucson's busiest streets. There's traffic going by both ways. He's got to think about her. He's got to think about the safety of the officers. He's got to think about the safety of the public. So what does he do? Well, one of the reasonable things that he can do is, and probably we argue the best thing he can do, is take physical control of her and get her off that median.
Of course. But according to her evidence, one of the things he does is shove her face into the bark of the palm tree. That's not getting her under control and getting her off the median. That's something distinct. So her evidence is he deliberately pushed me into the palm tree and caused me injury. So that's what you've got to contend with.
Right. So obviously, Your Honor, we don't agree with that, but you're dealing with what she's alleging.
Well, it's her statement. It's her evidence.
Right. What she does, she talks about being pushed or shoved into the palm tree by his body weight. E104 has her deposition at 28 lines 24 and 25. It's not. I just want to make sure we're on the same page of this is not a shove like I'm going to shove you into this tree. He is trying to get handcuffs on her, and he's pushing her forward. And that's how she's ending up into the tree. And her head is going, she also says her head is going between the tree, and she's getting scratched on her face and her shoulders.
Everything you're saying, though, may be true, but it sounds like you're making a jury argument right now. That's the concern.
The problem with that, Your Honor, is if you go to the second prong, there's nothing in the law that says that what he did is wrong.
Well, I'm not sure about that. The law says you can't use excessive force. And I mean, maybe I'm viewing this way
In particular circumstances, excuse me.
Well, I think excessive force is defined differently in particular circumstances,
Yes.
but it's clear you can't use excessive force. And so the question here is, when you're arresting someone, how much force is excessive? And maybe I'm looking at this too simple, but when somebody ends up with a big gash on their forehead and on their arm, it suggests that the force might have been excessive, or at least enough that you can, go to a jury.
She's at the palm tree. We didn't put her at the palm tree. And when he goes to handcuff her, that's where she ends up being, is the palm tree. It's not like, and what he's interested in is handcuffing her and getting her under control.
Yeah, but the thousands, hundreds of thousands perhaps, of handcuffings take place without ending up with this kind of injury.
Well, it's where she was.
I would dare say that there's a lot of handcuffs that take place near palm trees that still don't end up with medical attention necessary.
Well, Your Honor, it's the fact is she started with Tejas leaning against the palm tree, and she's standing next to her, and she's non-compliant and arguing with the officers, not giving ID, and she's on a median, and he has to make this split-second decision basically of what he's going to do. And what he does is says, I'm going to get you under control physically. I'm going to take you physically and get you handcuffed. And it's minimal force. It's body weight and handcuffs under the Luptal case, and Your Honor, the Cheney case that I cited in supplemental authority. There's no batons, there's no tasers, there's no knee strikes, there's no pepper spray, there's no kicks, there's no punches.
No,
There's
just
none of
thrown
that.
against
Why
the
not
palm
try
tree
the
face
case?
first.
Because how does the level of specificity get established in the absence of trials? There are obviously fact questions here. You have one version, she has one version. Why not try the case and let the jury decide under appropriate instructions?
Because under the second prong, there's nothing that says that what he did was unconstitutional.
I think Judge Nelson pointed out there's lots of case law on excessive force.
There is, but there's none of them that are that specific to this situation. And
No, I sort of disagree on that, because I think, the principle, and by the way, I'm very sensitive to your arguments as a general
I
matter.
understand, Your Honor.
But
That's why we're here.
Yeah, but it seems to me that excessive force. when
That's
you're
why we're in your
handcuffing
courtroom,
someone,
because
at
we
least
give
my
good
understanding
judgments
of it, again,
for
this-
us.
I may be off base. But my understanding is when they complain about excessive force in handcuffing, usually what's required by the courts is to show some sort of medical attention necessary, and that's how you distinguish between true just made up claims, because I'm sure that handcuffing someone is uncomfortable, detaining someone is uncomfortable, but when it reaches the level where you need medical attention, that is to me where that line is, where there's at least a body of law that makes it clearly established that this at least arguably is excessive force. Now, you may well win before a jury. I don't know all the details of how much she was resisting like that, but it seems to me that when there's medical attention required, that's where the line is. Disabuse me of my notion.
If there was the only medical attention that was required here, Your Honor, was one visit where she got some, I believe, some topical ointments. There was nothing else that she did.
Oh yeah, but you've seen the pictures.
I would also point out, Your Honor, that under Luptal, the fact that there's injury doesn't mean it's excessive force. That is not a proper logical analysis, according to Judge Gould in that case.
Okay, of course, that's right. Now, I'm not taking this comment out of your time. It seems to me that this is an example as to the waste of the interlocutory appeal. This would have taken you, a day's trial, and you would have won. You're likely to win if we send it back. Meanwhile, then we've got delay, we've got appellate briefing, we've got a whole panoply of stuff we're doing. You could have just tried this darn case. That's just a comment, and let's hear from the other side. We'll give you wanted to reserve 2 minutes. We'll give
Yes.
you 2.
Thank you.
We've taken you over. We'll give you 2 minutes.
Thank you.
This is what I want to hear.
May it please the court. Good morning. My name is Damian Gallagher, and I'm here for Ms. Mina, the appellee. I'd like to start at the point that Judge Malloy noted that this case is coming down to whether it's a pine tree or a palm tree, and that simply is not the law within the Supreme Court nor this circuit, as it was clearly established in 2016, as it is today, that an officer may not employ non-trivial force against an individual who is not resisting arrest nor passively resisting arrest.
So how do we determine whether it's trivial force? Is it, I mean, can we look to the injuries? Is that determinative or is it not determinative?
Your Honor, in evaluating whether or not the force is trivial or non-trivial, it of course is a reasonableness inquiry under the Fourth Amendment, but typically in the excessive force context, it's evaluating whether or not that force was necessary and the degree of that force was necessary in effectuating that arrest. And here it was non-trivial because Officer Massey had Ms. Mina within his custody when he was handcuffing her. And once he pinched his hands in the handcuffing, that's when he retaliated against her by thrusting or shoving, or whichever verb this court chooses to adopt, and threw her into a tree where, as this court has noted, she was bleeding and had scrapes on her face and shoulders.
Well, how do you establish the level of specificity? And I refer to my colleagues' concurrence in the Green case, talking about the U.S. Supreme Court articulating that it can't be at a level of generality, but it doesn't have to be a case directly on point. How do you balance those things? And so we can figure out whether or not there is qualified immunity.
Your Honor, this court in Ostavinsky, as well as the Supreme Court in Anderson, has noted that a law is clearly established when a reasonable officer would understand the contours of the alleged misconduct and would know that the action would violate those contours. And here, we have defined this at a level of specificity, that an officer may not employ non-trivial force against an individual who is not passively resisting arrest. This court has made that clear in Graveland-Blondin. And if I may, Your Honor, this court has stated, though these cases do not concern tasers, they need not, citing Diorle, it does not matter, and that no case of this court directly addressed use of that particular weapon. We have held that an officer is not entitled to qualified immunity on the grounds that the law is not clearly established every time a novel method is used to inflict injury. And in Graveland-Blondin and Meredith, whether it's a taser or whether it's handcuffing, this court has focused on the degree and necessity of that force, not the particular weapon. And additionally, this court has focused that in Mendoza that the very act in question does not have to be previously established, again relying on the legal principles and the holdings from this court, not the particular weapon.
Well, the excessive force cases we're accustomed to seeing, they're almost all gunshots. I've never seen an excessive force case, where the injuries were so minor. Are there any other cases of which you're aware where the excessive force resulted in injuries of this sort? I mean, I don't want to put them aside in the sense that there's no injury. There was clearly injury. We see the photographs and so on. But are there other excessive force cases in which the injuries were of this sort?
Yes, Your Honor. In Meredith, there was a tight handcuffing case, and there the injuries were scratches on one's hand, on the wrist, I believe, and it's almost similar to the ones in the case at bar. Although it does seem that the injuries that Ms. Mina suffered were, rather bloody and uncomfortable. But it's also worth noting to stress that her injuries are not only physical, but they're also emotional and psychological damage as a result of this incident.
Well, but is there any case law that suggests we can consider the emotional and psychological damages?
Your Honor, I don't believe, within my knowledge of this circuit, addressing that on but the inquiry into whether or not the Fourth Amendment right was violated has not focused on the resulting injury, but rather the violation itself and whether or not the officer's conduct violated that Fourth Amendment inquiry. And this court has approached that with a balancing approach in Miller v. Clark County by identifying first the intrusion onto the Fourth Amendment right and balancing that against the government's important interest. And here it is, of course, our position that when Officer Massey employed this push, shove, thrust of Ms. Mina into the tree, that any government interest that they attempt to rely on under the Graham factors, whether it's the severity of the crime, whether it's a concern for her safety, all weigh in favor of Ms. Mina, given the fact that, Your Honor, she was charged with Arizona Statute 132412A for failing to provide her name. And counsel for appellant even admitted, and as well in briefing, that Officer Massey only asked for her ID, but then admitted that she did not provide the ID, but the law doesn't require physical ID.
Does the nature of the offense have any corresponding relation to this? Meaning, if they had a reasonable suspicion that she had drugs on her or a weapon on her, would that change the analysis? Here, it's just failure to show ID, as you mentioned. Does that change the analysis here on the excessive force that could be used?
Your Honor, it could, because it is a factor, and it is a factor to be considered. However, this court, in cases of misdemeanors, obstruction to justice, domestic violence, and even certainly in this case with failing to provide one's legal name, has hardly warranted the need for force, because the offenses are minor and because these offenses are not violent. In the Meredith case, as I mentioned before, Your Honor, that was they were investigating tax fraud, I believe, which this court classified as nonviolent. And so, yeah, it could be a factor, but because here, at most, it is a misdemeanor. But one, we do believe that Ms. Mina didn't violate this law, and Officer Massey in his deposition admitted that he never asked her for her name, he only asked for her ID, and therefore not even violating the law. And so to the extent that Officer Massey used force that was not necessary, this force was non-trivial and violated Ms. Mina's constitutional right. And because this was clearly established in 2016, as it is today, we respectfully ask this court to affirm if the court does not have any further questions.
Okay, thank you very much. I do have one further question, and this is for the courtroom. You're a law student?
That's correct, Your Honor.
And where are you a law student?
I'm a third-year student at William & Mary Law School.
Okay, thank you very much. And we would like to compliment you on the quality of your presentation. I'll compliment you too, but you do this for a living.
Yeah. Thank you, Your Honor.
2 minutes on the clock, please.
Very quickly, Your Honor. He mentioned Gravela and Meredith, both bystander cases. I just want to...
Night, Claiborne. Love you, buddy.
Gravela itself said there's a difference between a bystander and someone who is, quote, integrally involved in the volatile situation to which officers were responding. Meredith.
I'm with you. I agree with you on that. Although, again, I guess I just asked you the question. She's charged with not showing her ID. That seems pretty low on the totem pole. Maybe not a bystander, right? But maybe one step above a bystander.
Sure, but they're investigating possible domestic violence and underage drinking.
Not from her. Oh,
she's on the median with her
no,
Paige.
but I mean, are they? Oh, yeah, I see.
When they go to the median and need to get her off the median, those are the crimes. Yeah, I would just very quickly, Your Honor, on a case called Matos v. Agarano that this court has decided, where domestic violence is the volatility of those situations is recognized and the great danger of them is recognized. So this is not just she didn't show ID. There were serious matters to be looked at. I'd also mention just Parker, that Parker only said in 2018 that a shove would not be, there was nothing to say it would be a constitutional violation. Clearly in 2016, that's also the case. So we're always back to this second prong, and that's where we think we win. I will finish with simply saying I also want to compliment my opponent for his argument. We think the evidence, if you look at Mina's testimony, there is no case law that says there was a constitutional violation here that would have put the officer on notice, and we ask that you reverse. I simply want to say that however uncomfortable I was, I enjoyed our colloquy. Thank you.
Thank you.
Thank both sides for their very good arguments. Mina versus Massey, submitted.
All right, folks, and here are my final thoughts. This video indeed carries a lot of educational value. Understanding legal terminology along with being able to pinpoint Supreme Court case laws could possibly help you win your own court cases. We live in an age of information, and lawyers aren't intelligent aliens. They're human. Most of the time, they just take your money and hang you out to dry If you paid attention to Massey's attorney, he was trying to defend a violent cop and excuse his actions. Mena's attorney was young and hungry. He did an outstanding job knowing case laws and how to present them. I hope he stays on the up and up. I mean, there's a reason they call attorneys the devil's advocate. In this video, we understood that cops still need to afford people the opportunity to identify, even if they refuse to hand over their identification card. But that is only if a cop can articulate a reasonable, articulable suspicion of a crime. The fact that Mena was not charged with domestic violence, nor was she an intoxicated minor, and they only charged her with failure to identify, which is a secondary offense, is mind-boggling that the district court would actually rule in favor that Massey had probable cause to handcuff her. Remember that judges won't rule in your favor if you don't make the right arguments. These types of videos are important to analyze because we can begin to understand case laws and protect people from getting ripped off by incompetent lawyers. If you feel the need to hire an attorney to defend you, ask them important questions to see if they'll be good for you. The first thing every attorney should be able to answer is the 5 freedoms of the First Amendment. If they can't answer that, walk out of there faster than you would a shopping mall when you see a gunman ready to shoot up the place. And before you go, we're going to give you those 5 freedoms of the First Amendment. So if you see a cop, you can teach a cop. You have the freedom of speech, freedom of press, freedom of religion, freedom of assembly, and freedom to petition your government for redress of grievances. Remember that these documents, the Constitution, the Bill of Rights, were not written to give you your rights. You were born with natural rights. These documents were written to limit the scope of authority that cops have over we the people. It's about time they actually learn it and not just fake that oath that they swear to when they get that gun in the badge. I'm going to be dropping more of these types of videos in the future and try to highlight case laws as I go. I'm still in the infancy stage of learning these things, but I'm determined to stop bad cops and make this a better place for law-abiding people like you and I. I'll see you guys in the next video. Peace.
All right, I just wanted to update you guys, the ones that watch me all the time. I appreciate you guys. So hopefully I'll know something by tomorrow. If not, I'll try and go live tomorrow. I got some running around to do and stuff, a little bit of work. Love you guys. Thanks for riding with me. Have a good night.